I have one more question on the non-delegation doctrine, since you're teaching it today. When you look at this, like, do you have a sense, as someone who watches the Supreme Court as intently as you do you have a sense of like what their plan is? Like, like you say breadcrumbs, but really on many respects, it's like building blocks, right? Or in this instance, they're building blocks to tear something down. But what do you anticipate? Do you have a notion of what path they would take? Like, in other words, here I can anticipate in this case, they did this with the OSHA thing with the vaccine mandates. They didn't seem to hit on necessarily any big principle, but they narrowed what constituted a workplace threat, right? I mean, they basically said a workplace threat has to be unique to the workplace, as opposed to the idea of coming to work increasing a threat that may exist outside in society. And the implications of that are pretty huge, right? Like, well, guns are dangerous outside of society, so you can't say that people just waving a gun around at workplace is dangerous, because it's dangerous if you go outside. But it's not necessarily the relationship between Congress and OSHA, let's say. What do you anticipate they're going to try and do with this case to ultimately get to that point where they sever the ability of an EPA, of an FDA, of an SEC, we could just go on, to use their expertise to carry out the spirit of a law that is passed by Congress?
Right. So this is the thing. I don't think it is one case in particular. I think any case that gets there that is an administrative law case, the court is going to use, at least the conservatives in the court are going to use any principle that they can pull out to actually dismantle it. And so one of the things we saw was this sort of quote unquote major questions doctrine. The idea that if there's a major issue that Congress wants a regulatory agency to tackle, they'll give them very clear and explicit authority to do that. And that sort of the broad language giving broad discretion to an agency is not enough. Now you talk about the non-delegation doctrine, and that's the idea that Congress cannot give too much of its power or a certain portion or type of its power just to administrative agencies. And so, where we need technical expertise and sort of careerists to actually guide what our everyday regulations look like, they're not going to be able to do that because Congress obviously doesn't legislate at that granular level. And so I think this is really part and parcel of a larger agenda, which is to get rid of, or at least to neuter, the administrative state, right? And so this idea that we don't need this fourth branch, if you will, actually making decisions for us and making the sort of informed decisions for us about what is helpful and useful and safe for us to live our day-to-day lives. And this has been a project for a very long time. There was a case that I just taught to my students, this Gundy case. And, it was basically talking about delegation and whether, in a specific sex registration statute, whether Congress gave too much authority to the Attorney General. And lo and behold, they didn't want to use that vehicle because we were talking about sexual people who had to register for sexual crimes. But it was very clear from what the conservatives said. They basically said, we need another case to actually effectuate what we want to do. That is to say, we don't want to take a sort of sex offender to be the poster boy for what we're doing to dismantle the administrative state. And so I think what they're seeing with these environmental cases and OSHA cases and any other case that comes under the ABCs of the federal government, they'll use those to employ any doctrine, whether longstanding or sort of made up in the moment, to actually dismantle the administrative agency and neuter the federal government, knowing very well that Congress doesn't pass laws and won't pass laws at that level of granularity.
We should say, when you talk about destruction of the administrative state, it was 5 years almost to the day at CPAC that Steve Bannon announced that was the agenda of the Trump administration. 3 Supreme Court justices later, we are maybe not at mission accomplished, but maybe at mission accom. And
we're well along in the project. That's correct.
All right. Lastly, let me just ask you this question. This scenario, the nomination hearings happen over the course of the next couple of weeks, and she's nominated, she's confirmed, and Senator Dianne Feinstein, or let's say Senator Patrick Leahy, he passes away or something like that, and control of the Senate goes to Mitch McConnell by hook or crook. Is she still, when Breyer retires in, let's say, June or August or whenever it is she the Supreme Court justice, or can McConnell say, wait, no, we're going to have new hearings?
So this is an interesting question. I think procedurally it's going to happen in a way to avoid that outcome. Notably, there is a very young senator from New Mexico who recently had a stroke. And so the dynamic in the Senate already could have shifted in this weird way. We hope that he is getting well, and then he'll be on his way to be here for this vote and other votes. But I think what's going to happen is you're going to have the Senate go through the processes and basically vote and then hold her commission until the end. And that way she will have been voted on. And if anything happens afterwards, she will still have the right, because that's when she takes the seat, is when her commission is delivered to her. So I think they're trying to avoid that.
Justices.
They can. I just don't think that they felt was that sort of imperative. Or, for example, when it was Justice to be Justice Merrick Garland, who Ketanji Jackson actually replaced on the DC circuit when he became Attorney General, they didn't have the votes, and so that wasn't necessary. It wasn't sort of like as closely divided. And I think, having learned from those experiences, that will probably be the protocol going forward.
With Merrick Garland, they didn't control the Senate, so they couldn't have hearings. But I'm saying, why can't, after Ketanji Brown Jackson is confirmed by the full Senate, assuming you could get Manchin or Sinema on board, I mean, just put aside the question of the specific senators, why can't Chuck Schumer say, you know what? Let's have another one in reserve. Someone could die. Someone could get hit by a bus. We're going to confirm 2 more Supreme Court justices, and they just stockpile. But I mean, I know that sounds ridiculous, but I don't understand what the mechanism is any different.
Yeah, and I guess there could be this world where you theoretically vote for like 9 replacements of the current justices. But I'm that I cannot answer for you. I think it's probably going to have to do with this like limitation on the number of justices that you have at any point, and that you have to have an actual recognized vacancy stated and delivered to the president before they go forward. I'm pretty sure that is exactly why they're limited.
That's right, but I mean, is that a statute? Like, I mean, is it like we need a resignation letter before we can confirm somebody?
Yeah, well, the president can't make his nomination of the successor until there actually is a vacancy resigned to him. And so that is the sort of building block. In your world, I love your world, where the president just makes 9 appointments right now and then just has them holding into perpetuity until we get those vacancies. But there has to be an announced vacancy and an officially announced vacancy to the president before you can actually make a replacement nomination.
All right. Well, I tried. Professor,
I like your Senate.
Yeah, tell me about it.
Well, the point is, I think, like, bend the rules because Republicans have done so, and I'm not opposed to like that kind of a thinking, obviously.
If there's a way to do it, I think we should be doing it. Wilfred Codrington, Assistant Professor of Law at Brooklyn Law School, thank you so much for your time today. Really appreciate it.
Thank you, Sam and Emma.